Start. The above mentioned discrepancy came to notice during the hearing on these appeals. It has not been made a bone of contention by the appellant oblique convict in any of these appeals. Undoubtedly, such error should not have occurred. Without doubt, the criminal code cannot adopt cut, copy, and paste procedure while preparing the judgment. But then, having regard to the fact that the appellant oblique convict does not dispute that the evidence laid on the file of criminal case number 1629 oblique 2010 correctly referred to the proper documents relatable to the said case, and they were accordingly put to him at the stage of his statement under section 313 CRPC, so much so that he even candidly admits the signatures CRL appeal numbers 73/13, 74/13, 75/13, 90/13, 91/13 and 92/13, page number 9 of 55 on the check in question. No prejudice has been claimed or can be claimed on account of this error, which must be treated at the most a clerical error. Thus, the judgment in criminal case number 1629 oblique 2010 has been read at the hearing on these appeals as corrected and in accord with the correct documents already on record. Para. At this stage, it will be appropriate to take note briefly of the background facts leading to these judgments of the trial court to the extent that they can be culled out from the three complaints and the evidence adduced on behalf of both sides. Para. The complainant alleged in each of these three complaints that he is the proprietor of business run in the name and style of Messrs. Bajaj Studios with office at A5 Mayapuri Faisal, New Delhi 110064. He alleged that he has had business relations with the company named Reminiscent in bracket India Television Limited in bracket hereinafter referred to as RITVL bracket out, in which the accused Sunil Menon alias Makul Marathur Sunil was the main active director. The complainant claimed that on account of the said transactions with RITVL, the latter had made a default in timely clearing his outstanding dues to the tune of rupees 71,88,544, and that he had been constrained to file a civil suit bearing number CS in bracket OS 575 oblique 2005 titled PK Bajaj versus CRL appeals numbers 73/13, 74/13, 75/13, 90/13, 91/13 and 92/13, page number 10 of 55, Reminiscent in bracket India Television Limited in bracket hereinafter referred to as the civil suit in the High Court of Delhi for recovery of rupees 89,13,794, which would include the aforementioned principal amount along with interest calculated at rupees 70,25,250. It further appears from the material on record that Honorable High Court of Delhi in the course of hearing on the said civil suit was informed that the RITVL had entered into some transaction regarding sale of its property described as A4 Guru Kripa Building, Andheri West, Mumbai 400053 with Messrs HK Pujara Builders, 301 Krishna Kumar, 30 VL Mehta Marg, Ville Parle in bracket West, Mumbai 400056 for consideration of rupees 2 crore 45 lakhs in terms of conveyance deed dated 27.04.2005 on the application of the complainant as plaintiff in the civil suit. Honorable High Court wide order dated 1.8.2005 had directed the said purchaser of the property in bracket Messrs HK Pujara Builders to withhold bracket out a sum of rupees 90 lakhs out of the said total consideration payable by them to RITVL apparently to secure the interest of the complainant herein. Para. As per the documents submitted by the accused himself, vide a subsequent order dated 3.1.2006 passed on certain interim applications filed in the course on the said civil suit, Honorable High Court noted that it was the case of the defendant in bracket RITVL that CRL appeal numbers 73/13, 74/13, 75/13, 90/13, 91/13 and 92/13, page number 11 of 55. There was no privity of contract between him and the plaintiff to the case in bracket complainant herein bracket out, as the entire dealings had been with Mr. Aman Bajaj, son of the latter. Certain documents were referred in that context and also in support of the contention that the agreement, which was subject matter of the said civil suit, contained arbitration clause. It is now conceded on both sides inter alia, in light of the documents submitted by the accused with his applications under section 391 CRPC before this court, that vide a subsequent order dated 11.11.2009, the dispute which was the subject matter of the civil suit was referred to arbitration with the consent of both sides. The learned arbitrator to whom the matter was referred is yet to give his reward in that case. Para. As revealed by the complaints and the documents on record of each matter, it has further been the case of the complainant that Messrs. Bajaj Studio had been constrained to institute prosecution through criminal complaints. Full stop. Over.